Welcome back. I'm back. Welcome to Laughter in the Law, where we talk about the law with a lighthearted twist. This is Jackie, our fearless captain at Flexner Hauser Injury Law, and I would like to think that I am your valued first mate. Right?
Absolutely.
No? Yes.
Absolutely.
Maybe.
We've replaced you a lot this through this series of podcasts, but that's been good.
Yeah, I'm not hurt.
No?
Not hurt at all.
What you don't know is she's sitting behind the camera at every shoot. So she's like giving us the cheers and the yays. And so she's still here.
Yeah, I still have to be a part of it in some way.
She's still here. But we brought you back for this one so you can help us out with, we're going to do a book review.
I am an avid reader. I love reading books. I'm usually fiction, whereas you are nonfiction.
True.
So I'm really excited today to hear about one of your favorite nonfiction reads.
Yeah. Hey, so you said this over Christmas, and in case people don't know, you're my daughter.
That's right. If this is your first time tuning in, I am her daughter.
Yeah.
Yes.
I stole her away from the college system where she had benefits and retirement and made her come work for me. So, but anyway, so in case, so that they don't think that, like, you know, there's any other, that's our relationship. You're my daughter.
Yes. Yes.
And so over Christmas, you were talking about your goal for 2024 was to read how many books?
My goal was 125. Work kind of got in the way.
I mean, whenever you say avid reader, I want people to understand what avid means in your world. So.
Yeah, and the thing is, I'm not reading a book that's, you know, like 250 pages. I read thick books.
Yeah. And so you didn't make the 125.
No.
What did you make?
I mean, I did crest 100.
Okay. What a shame. You're such a failure. You're so disappointing.
I think I ended up around 104 and a half.
Okay.
But
right.
Yeah.
And I may have crested at 4.5.
Well, you read a lot for your clients, for your cases and such.
I do.
There's a lot of
Once you read
reading.
a couple of once you go through some case law and draft some briefs, you know, you get home at night and you're just, your brain is just like, please don't make me read the directions on this pot pie.
Yeah. Yeah.
It's just, you just get weary of it. But I do try, one of my goals for the new year and for the year has been, you know, to work fun reading into my schedule. And so I've been trying to do that.
I think you become a more fun person when you do that.
I'll try to be more fun. It's
Okay.
That's maybe my goal should just be more fun. Just be more fun, whether it's reading or whatever. So
Yeah.
So this is a book that isn't necessarily a fun read. It's actually a legal read. And I like reading, obviously, books that are related to the law. They kind of, you know, I do trial work. And you always want to, if you hear about a good case in town, this is kind of what geeky lawyers do. If you hear there's a good case in town and closing arguments are Tuesday morning at 10 o'clock, you're going to be sitting there Tuesday morning at 9:45 waiting for closing arguments. You want to hear the closing arguments and you want to, you know, whether whoever side it is, and, you know, you don't have to cheer for one side or the other. You just want to hear closings and see how people, you know, wrap their case up. And so that's the book that we're going to talk about today. It's called Ladies and Gentlemen of the Jury is the name of the book. And it's some of the greatest closing arguments of the modern era. It's not, 200-year-old cases or anything. These are a lot of the modern cases. And so I thought we'd take one or two of those and chit-chat about them a little bit.
Yeah, but as you were kind of pitching this book to me and saying, let's talk about this book, you also shared a really fun closing argument story that isn't modern law. It's a little further back. And
it's not in this book.
No. And what I found funny about this is that it was kind of in the it's humorous, even though a general rule is you don't want to use humor in your closing arguments.
Yeah, the general rule is humor falls flat in a closing argument a lot of times.
Yeah.
There's two general rules. Number one, try to avoid humor. It typically falls flat. And then the other thing is that I try to avoid quoting the Bible or scripture. Usually judges don't like that. If I'm going to quote something from the Bible or scripture, like thou shalt not kill,
Yeah.
I wouldn't do that because obviously I don't do criminal law. But usually I want to get permission from a judge before I do that. Now, you'll see in a lot of these books where people do quote from scripture. And so I think it would be very interesting to know the backstory, whether or not they did get the court's approval before doing that. Because so many times, we're so concerned about undue influence on the jury.
Right.
And so that sometimes is a no-no to quote from scripture or those other, or to make
humor.
a joke. Yeah.
So, but before we dive into this book,
Okay.
can you please tell the story? Because it's so much fun. So
You say it's fun, and I'm cringing a little bit from, but there's honestly, I have other books about great closing arguments, and there's like a whole section on Abraham Lincoln.
Yeah.
He was a lawyer before he was president, and so he had a lot of good quotes from several different books about closing arguments. And so one of the ones that's kind of humorous is, there was this particular case. He was arguing the closing argument. He just didn't feel the jury was going to render a decision in his favor. He could tell from their body language or the way they were, you can just read people while you're standing there staring at them eyeball to eyeball. And you're like, this person's all for me. And this person's shaking their head no. And, so you can read people in the jury box a lot of times. And so he's not getting a good vibe from the jury. And so he tells this story in his closing. He said, "Now, ladies and gentlemen of the jury," he said, this case is like the farmer who was sitting on his front porch, and his young son, comes running from the barn, and he says, "Daddy, Daddy," he said, "come quick. The hired hand is out in the barn. He's pulling his pants down, and she's pulling her dress up, and they're about to pee on the good hay."
I'm sorry. I know I've already heard it before. It's just the innocence of a child.
Yeah, the innocence of a child. And so the father says, "Son, you've got all the right facts, but you've reached the wrong conclusion." And that was how he let the jury know he just didn't feel they were reaching the right conclusion. So once again, humor sometimes falls flat, but I got to believe that little, and that's Abraham Lincoln telling that story in, the 1850s and 60s. I mean, I got to believe that maybe got his point across. I don't know how that jury trial ended, but that was a good story.
Yeah.
So.
Yeah.
Anyway.
Well, what are some, because, this is a collection of closing arguments from different, from different trials. So, and I know we can't talk about every single one today, but if you had to mention one or two, what ones really stands out and just kind of was like, whoa?
There's a couple. Number one, there's one that's a civil trial, and it's the Silkwood trial.
Okay.
And I know Silkwood predates you.
Yeah.
So you probably would have to do a little research on it. And then the other one also predates you, and it almost predates me. But so the Silkwood trial is one, and then the other one is the civil rights trial, the Medgar Evers trial. But we'll talk about Silkwood a little bit. That's a little bit more lighthearted.
And also is related to your line of work.
Exactly.
It's a civil case.
Exactly.
Okay.
So for those who don't know the history of Silkwood, I'm going to do what was it used to be called?
A brief synopsis?
No.
Summary?
We used to do this in school whenever we didn't want to read the whole book. We read the Cliff Notes.
The Cliff Notes. Okay.
I'm going to do whenever you didn't want to do the assignment, but you wanted to get credit.
Yeah.
You did the Cliff Notes version. So I'm going to do Cliff Notes version of Silkwood.
Thank you.
Silkwood is about Karen Silkwood, and she worked at a plutonium plant. It was called, let me look at it, make sure I got it right. It was called Carnegie. It was Carnegie plutonium plant of some sort, and they made plutonium pellets. Plutonium is very dangerous. And so she was part of the union, and she was a union activist, and she was elected to the union board. And she testified in front of Congress about how unsafe the conditions were at the plant. And, obviously plutonium can kill you if you're exposed to it. And then plutonium was discovered in her home and on her body. And so, that was a clear indication that there was not correct safeguards at the plant. There's a great movie about it. I watched it as a teenager.
Who's in it? Is there anyone famous in it?
Cher plays Karen Silkwood.
Oh,
Yeah.
Cool.
If I'm not mistaken, Cher plays Karen Silkwood.
What is the name of the movie?
Silkwood.
Oh, well, that's appropriate. Okay.
There. If you take a break from a book, you can watch that movie and or just read the book. There is a book about it. There's a book called I think it's called Who Killed Karen Silkwood.
Oh.
Because what happens is she is on her way actually to give an expose interview to a New York Times reporter, and she has a mysterious one-car accident and she dies.
Wow.
Yeah.
Was this before or was this during the trial or after the trial?
The trial resulted came after her death.
Okay.
Yeah.
Wow.
So there was a trial against Carr McGee for their violation, for their strict liability offenses for letting. Well, I got to go to strict liability now. But there was a trial against Carr McGee for the exposure of Karen Silkwood to the plutonium, which they found in her home and on her body. And so the family sued as a result of that. They sued the nuclear plant for poisoning her with that plutonium. And the closing argument is kind of famous. And they give the majority of the closing argument in the book, but it's really pretty interesting because it's a strict liability offense, which I think we talked about very briefly in a podcast a long time ago. Mm-hmm. But strict liability offenses are offenses where you're liable if your activity causes harm, regardless of how careful you are.
Oh, wow.
So an example would be if you in the back of your car today had a package of dynamite. Mm-hmm. And you're doing everything. You've padded the dynamite. You've got a sign on the back of your car that says, "Be careful, dynamite." Mm-hmm. But if that dynamite explodes, in spite of everything you've done to be careful, you're liable because it's a strict liability offense. And the theory is it causes great harm. Whatever this offense is, it causes such great harm that you have to be liable. Mm-hmm. You cannot escape liability because you were super careful. Mm-hmm. So explosives are an example. Trucks on the highway that carry hazardous materials are strictly liable if their hazardous materials leak or are exposed to the general public. If they have a wreck and they leak, they're liable for that.
Right.
And then another one is wild animals, people who keep wild animals. There's been multiple cases, but there was a famous case down in Florida where a fella kept tigers. He was raising tigers. And unfortunately, he started to trust the tigers who were caged, and he would go out every night and feed the tigers. And I think it was either his daughter or his stepdaughter. He took, and the tigers, would let them pet them through the fencing and things like that. But he stepped into the cage to feed the tiger, and the little girl stepped just in behind him. And before he knew it, she was gone. Because that's what the tigers were waiting for. So they were a wild animal. They were doing what wild animals do.
Wow.
Right? And so he was strictly liable for that offense. I think it was a stepdaughter because I think the biological father sued him for the wrongful death of his daughter, now that it's coming back to me. So that's what the argument was in Silkwood against Carr McGee, the plutonium plant, is that they were strictly liable. They were doing something that was inherently dangerous. They had a duty to protect others from this inherent dangerousness, and they did not fulfill their duty. And so you have a question. I can feel it.
I do. And this may be out of the range of your knowledge, but the plutonium, could they breathe it in, or was it just by contact, like if it touched the skin?
I do not know. I do know, I think it was a skin contact, if I'm not mistaken. I don't think it was internal, but once again, that's beyond my recollection of how she was exposed.
I need to watch the movie.
I know. I cannot remember how she was exposed.
Okay.
Specifically.
Or read the book. I need to read the book.
Yeah.
But okay, so what's so great about this closing argument in this case?
So I gave you the Florida example of the tiger that unfortunately attacked the little girl, but it's strict liability. The original argument is based on a lion that got away. A man, the attorney in Silkwood actually tells the story. He says, there was a man who had a lion, and he brought the lion home, and he put him in a cage, and he knew that lions were dangerous, and so he locked the cage, and he wouldn't let people go in the cage. But one day the lion got away, and the lion went into town, and the lion killed people, and the court held, you're responsible because the lion got away. Mm-hmm. The lion is a dangerous animal. And so the closing argument, I'm not going to tell you the whole closing argument, but the closing argument, the line that he used, which he used in his opening as well, is if the lion got away, Carr McGee has to pay.
Oh, that's catchy.
Yeah. And that's just really, and he talked about strict liability, and he talked about the theory behind it with the lion, and he talked about Carr McGee and the exposure to plutonium, and he just sums it all up in that. It's almost like the O.J. Simpson case where, if the glove doesn't fit, you must acquit. But it's if the lion got away, Carr McGee must pay.
And Carr McGee's lion, the plutonium, did get away because it was found outside of the facility.
Yeah. And then he goes on and he talks about that. And he whenever he's talking about Carr McGee, he goes, it was your lion. It was your duty. You have this inherently dangerous thing on your premises. You have a duty to others to protect them from all danger from that. But he keeps referring to it as a lion.
Even it's just great imagery.
Yeah.
That is great imagery for the jury.
Yeah. Yeah. Even if you have a good cage, even if you have a lock on the door, even if you did everything you could, even if you had trained people watching the lion, even if it's not your fault, it's a strict liability offense. Fault doesn't come into strict liability. Mm. It's a strict liability offense because of its inherent dangerousness. Mm-hmm. And so he took the very complicated notion and legal concept of strict liability and broke it down into a rhyme. If the lion gets away, Carr McGee must pay.
Yeah.
And so clearly the jury attached to that. They returned a 10-point-something million verdict.
Wow.
For Karen Silkwood. Obviously there was a lot of legal wrangling after that. Her family did recover some of that money. They didn't recover all of it. But I thought that was a really good closing argument because he takes a very complicated legal concept and very complicated facts and just narrows it down to that one sentence that even the most uneducated juror can go back in the jury room and repeat if that's how they're voting and just say, well, what do you say about if the lion gets away, Carr McGee must pay? What do you say about that? So that certainly was, I thought was a very effective closing argument.
Yeah, and I know in one of our previous podcasts, we do talk about, what you should know as a juror and things that jurors don't know. And so that's something you have to think about every time you go to trial, is that these jurors are not going to be attorneys or former judges or anything like that. They're going to be just common people. And so having something, breaking it down and making it that easy to retain and understand, I mean, that was a really great execution on his part.
Yeah, absolutely. I mean, strict liability is complicated. And obviously, after the closing arguments, the judge is going to read the law, and the law is just going to, sometimes that just gets very cloudy whenever jurors are having to listen to it being read to them, to 20 or 30 pages of law being read to them about this is what you're going to base, evaluate your facts on and the law to reach your analysis and to reach your conclusion. And so, once again, that's kind of a mastermind to take something very complicated and make it simple.
Yeah.
Yeah.
I'm impressed.
Yeah.
I think I might pick up this book and read that full closing argument later on.
Yeah, watch the movie. Seriously.
Watch the movie.
Watch the movie, but also then once you see the movie and then you read his closing argument, because the movie doesn't deal with the lawsuit. It deals with her being an activist at this plutonium plant. Of course, obviously, it's after her death. But it's a good movie. I was very young whenever I saw it, and I just remember it was a very technical movie, and I think they did try to be as accurate as they could be. From what I can, I've only seen it one time, but it was.
But it would give me the context
Yeah.
to then be able to really appreciate
Yeah,
the excerpt in this book.
yeah, absolutely.
Okay, cool.
So that's one of them. The second one we'll talk about is a criminal case. It's not a civil case.
Which is not something we do. We don't do criminal. But you can still appreciate a good closing argument.
You can. And, you know, whenever you start looking at books about closing arguments, 99% of them are going to be about criminal trials.
Well, they're usually more interesting.
They are. I mean, you know.
They got a lot of drama.
Yeah. You know, I know if we know of a good criminal trial going on and once again, we'll rush over to the courthouse, sit there and watch closing arguments. Even though I don't do criminal law, it's just interesting to watch other lawyers at work in a good criminal trial. So those are the ones that get your attention. And so there's one in this book about a civil rights leader named Medgar Evers and his assassination and the eventual conviction of his assassin.
And correct me if I'm wrong, but Martin Luther King Jr. was a contemporary of his, right? They were around the same time?
Right. Yeah. This was in the 60s, early 60s.
Okay.
And Medgar Evers was a secretary for the NAACP field office. And I can't remember the city, but it was in Mississippi.
Right.
I don't remember the city off the top of my head.
Okay.
But it was in Mississippi. And this is according to the book. This isn't my quote. This is their quote. Mississippi being the most racist state in the South is what the book says. I don't know what survey they took, but anyway, that's what they said.
Well, there's a lot of stories.
There's
civil
some
rights stories that
check off some
happened in
boxes.
Mississippi.
Yeah.
Yeah.
Now, I'm not dissing on Mississippi. I'm just saying.
Absolutely not.
Send your complaints to Ben Beisel.
Yes.
Those were his words.
Yes.
But anyway, so Medgar Evers was a grown man, had a family, wife, I think a couple of kids, 2 or 3 kids, and he was working with the civil rights and for the NAACP and reporting civil rights abuses and abuses with voter registration in Mississippi at the time. And so that was his primary job. So the year was 1963. And as he's coming home one night, he's drove into his yard. He's getting out of his car. He's approaching his house. And he is shot by a sniper. And killed on his front lawn in front of his family.
In front of his kids.
Well, I think that they heard the commotion and I don't know if they were outside. I mean, because it was at night, so I don't know if they were outside or they came outside. But anyway, he died in front of his children for certain.
Yeah. Wow.
And so he is shot by this assassin, this unknown, unseen assassin in his front yard. Through the investigation that ensues, they arrest a man, and his last name is Beckwith, I believe. Byron De La Beckwith is his name. For short, I'm just going to call him Beckwith.
Okay, all right.
But his name is Byron De La Beckwith. They through the very quick investigation, they arrest him. And he goes to trial the next year in 1964. And back in Mississippi at this time in the 60s, to be a juror, one of the qualifications was that you were a man and that you were white. So no women and nobody else of color. And so the jury of 12 men in 1964 could not decide whether or not he was guilty. There were 6 for and 6 against. And so that's called a mistrial. And in criminal trial, if you have a mistrial, you can try somebody again. It's not considered double jeopardy, which means you can't be tried twice for the same crime. But if there's a mistrial, you can be tried again. It's up to the prosecutor. So they brought the case again within a year. So they tried it a second time with the same facts, same scenario, not the same 12 men, but 12 white men. And that time, it resulted in a mistrial as well, but there were 8 in favor of guilt and 4 not guilties.
Wow.
Yeah. And
So what happens with a second mistrial?
well, same thing. The prosecutor can try the case as many times as they choose to, as long as it's a mistrial.
Wow.
But this prosecutor, and this is really a good tactic sometimes, which we try to educate our clients on. Sometimes the best practice is to wait. Let's be patient. Let's wait.
There's definitely some pros and cons with that.
There are. You don't want to wait on every case.
Right.
But I'm going to divert from my summary right here of the trial. But, I just had a case that I settled for a young girl where the UIM carrier wasn't going to award us anything. And I was tired of arguing with it. Now, she had settled with the bodily injury carrier. They had paid their limits. So we had a very good recovery for her. But I also filed an underinsured motorist claim to see if we could get additional coverage or an additional recovery. Just to see what else was out there. I'm not going to give up just because we got the primary coverage.
Right.
And the UIM carrier would not cooperate. They were like, nope, she's been paid all that her claim is worth.
Yeah.
And so I just said, let's wait. We had plenty of time. We didn't have a statute of limitations problem. And because I used to do defense work, I know a lot of times some of these carriers want to close out cases at the end of the year. They don't want that rolling over. Or some of these adjusters don't get their bonuses, and they won't call them bonuses, but they don't get their bonuses if a case gets a certain age, right?
Right, yeah.
And so we just waited. And all of a sudden one day, got an email. Hey, can we settle this case for X? And I said, nope, but we can settle it for this. And we did.
Wow.
And it was just a matter of, it wasn't like years. It was literally a matter of a few months.
Yeah.
I knew the end of year was coming. And I just said, we're not going to be in any worse shape because right now they're offering 0.
Right.
So we're not going to be in worse shape if we wait and we still get 0.
Yeah.
So, sometimes waiting is the thing to do. It's not always, but it's called patience.
Yeah.
And sometimes patience is a virtue.
So how long did they wait?
They waited 30 years.
Wow.
We're back to the case now, not my client.
Right.
We're back to the case.
Yes.
For Medgar Evers and Mr. Beckwith.
Wow.
They waited 30 years. Obviously, they were new prosecutors. Obviously, nothing else had really changed, except, as we often say, sometimes waiting is not the thing to do because memories fade, people die or move, and evidence disappears. So sometimes that's a problem.
Yeah.
But in this case, Mr. Beckwith was his own worst enemy because in the waiting, he decided he had gotten away with it.
Yeah.
And what did he do? He bragged.
No. Of course he did. Of course he bragged.
He bragged. So he had bragged. I think he had been in jail for some other offense. And he bragged, or maybe this was, I might be getting that wrong. He had bragged to one of his ex-Klan buddies.
Yes.
About getting away with it.
Okay.
And they couldn't convict him.
Wow.
You'd never convict me in Mississippi with 12 white men on the jury.
Wow.
So we wait 30 years.
Wow.
And they took it to trial, I think in the
And so this witness came forward and said, hey, I've heard him bragging about this.
This witness came forward.
Yeah.
And said, this is what he said to me.
Yeah.
And so they took him to trial for the 3rd time. And the beauty of that is because you don't just brag to one person whenever you get away with something because you're proud.
Yeah.
You're proud. You brag to more than one person. And so as it goes to trial and as the prosecution is actually putting on their case, another witness comes forward and says, hey, that Beckwith guy, he bragged to me as well.
Wow.
So now you got 2 witnesses that he bragged to.
Yeah.
And so they had both the witnesses testify. Now the concern was still, how do we avoid a mistrial again?
Yeah.
How do we say, because now Mr. Beckwith is this 70-year-old man.
And memories have faded. It's not so close to the surface anymore. Yeah.
So how do you do that? And the great thing, that's where this closing argument comes into play.
Okay.
And so we now have somebody who's 70 years old, and the prosecutor obviously knows that that's an important point. And so he makes a comment about that in his closing argument. And I'm going to read it to you. I'm going to have to put on my glasses to do it, but I flagged my page. I think I flagged my page.
Yeah, go back one.
There we go.
There you are.
Okay. So he says, let me put my eyeballs on. This is so good. He says, he talks about the court's giving you some instructions, and I'm here to talk, these are instructions you must follow. Mm-hmm. He says, this case is about whether or not this defendant killed and murdered Medgar Evers in June of 1963. We're talking 30 years later. He's talking about this. Yeah. You've taken an oath to make that determination, not on what ifs or maybes, but on the evidence. And here's where he addresses his age. And this doesn't say unless the defendant is of a certain age, because no man, ladies and gentlemen, is above the law. And if we start making decisions like that, that doesn't have anything to do with the law. Mm. Eventually, where do we draw the line? Do we say we're going to draw the line when the person is 70-something? And in another case, if they're 65? No. Regardless of his age, no man is above the law. And it doesn't say, unless you find that this offense was committed 30 years ago, it says, and he's talking about the law, it says, if you believe from the evidence that he did it on June 12th, 1963, he's guilty, and it's your duty to find him guilty. And then he closes out that closing argument with and he this is great. Hold him accountable, find him guilty, because it's right, it's just, and Lord knows it's time.
Wow. Wow.
Yeah. It's a great closing argument. And they do. He's 70-something years old, and they find him guilty for that murder. Yeah. The family finally had justice. Yeah. So those are and that's why criminal law cases are just so passionate and powerful.
Yeah.
But they always seem to make the books, and civil law cases don't. But I think there's some prejudice there. But I think there's good civil closings as well. Yeah. But those are just two of the closing arguments from that book that I just thought were good enough. And I don't know if people want to go around reading about closing arguments, just people that aren't involved in the law. But it'd be worth picking up from a library and reading it. It'd be really a good read.
Well, I typically choose fiction because I try to escape the world that I am in. But this is interesting.
Yeah.
And, these are real people.
Yeah.
And I feel like that is what makes it so much more powerful.
Yeah.
Because this is true life. This is things that really did happen.
Yeah.
And it's amazing. I'm glad that it's collected in a book so that you can just, feel that impact even now, so many years later.
Well, you think about it, it's only been in the last 30 years, maybe 40, that people don't attend trials because we have television and social media, and we have so many other things that occupy our time. Yeah. But people used to literally go to the courthouse. That was their entertainment, was to attend a trial.
Wow.
And I can remember in the early days of me doing this, I was a paralegal at that time, but we would have a medical malpractice trial, and it would be big news. And back in the 80s, early 90s, it's big news to sue a doctor in your neighborhood. And people would come to court to watch the trial. I can remember that. Or jurors would be sitting there, and they may get dismissed from the jury panel, and they just come out and sit in the audience and say, I want to watch this.
Wow.
I'm going to be here the rest of the day, or they may come back the next day.
Yeah.
And we just don't do that as much anymore. You don't see that. If somebody's sitting in the courtroom now, you're like, is that your next witness? Are they lost? Even a bailiff sometime will go out there and go, what are you looking for?
Yeah.
Because we're just not accustomed as much. The galleries, you think about the old courthouses, the galleries were huge, could sit hundreds of people. And now with the newer courthouses, they may sit dozens or a dozen. And it's just because we don't have the same amount of participants. And viewers that we used to have,
Spectators.
spectators that we
Yeah.
used to have. But yeah, closing arguments used to be a big thing. And so it's really pretty cool, these types of collections, because, there would be people in the audience and that would be what they would see. And that would be their, quote, entertainment for the day. And so these are really a good collection of those. And I think, and the book has some other civil matters as well as criminal matters in it. But those were two that are two of my favorite.
Well, thank you for sharing.
Absolutely.
And thank you for having me back on the podcast.
Yeah. Well, if you continue to do well, we'll let you come back again.
I appreciate that.
We'll let you do the closing today.
Okay. All right. Well, here we go. Ready?
Okay.
Thank you for tuning in. This is Laughter in the Law, where we talk about the law with a lighthearted twist.